Good morning. Thank you so much for joining us today. And sorry, I had to get my phone. You got to keep these people on time. This morning we're going to be talking about what reforms Congress should or should not make to the administrative state. And as many of you know, there have been a wide variety of proposals over the year to reform the way that administrative agencies operate and to adjust their position within the federal government. These proposals have come from many different quarters. The Administrative Conference of the United States over many years has issued a variety of recommendations along these lines. The ABA has developed recommendations, including as recently as 2016. Those are developed through the section on administrative law and regulatory practice. Proposals have come from scholars, from regulated entities, and from others as well. And these include everything from the REINS Act, from a variety of proposals seeking to modernize the APA, the Administrative Procedure Act, which of course was adopted in 1946 and has been modified, but in some of the most core respects, not amended since the time that it was enacted. In addition, there have been proposals for legislative reform that would affect the relationship between courts and administrative agencies, including by, for example, seeking to abolish Chevron deference or Auer deference. Now, none of these are necessarily new, but under unified government during the Trump administration, it seems that legislative reform has gathered some steam. And so today we have a really excellent group of panelists to talk about some of these legislative reform proposals. Each of them has deep expertise and also differing perspectives on whether these reforms are wise, and if so, which ones should be adopted and how. So I'm going to introduce our panelists in the order in which they will speak. First of all, we have Chris Walker, who's an associate professor of law with tenure at The Ohio State University, Moritz College of Law. He also serves as director of Moritz's Washington, D.C. summer program. And I'll just note, because it's particularly relevant for today's conversation, that in 2017, Professor Walker served as an academic fellow on the Senate Judiciary Committee, where he worked on, among other things, regulatory reform legislation for Senator Orrin Hatch. Next, we have Kathryn Kovacs, professor of law at Rutgers Law School.
That's the State University of New Jersey.
An important clarification. Professor Kovacs, before she joined the faculty, spent 12 years in the appellate section of DOJ's Environmental and Natural Resources Division. And in fact, when I was reading your profile, I realized that you litigated several appeals that I worked on as a clerk when I was at the Ninth Circuit, including the defense of the Navy's use of sonar. So she has deep experience defending administrative agencies and will bring that perspective. Next, we have Michael Rappaport, who's a Hugh and Hazel Darling Foundation professor of law at the University of San Diego School of Law. He also serves as director of USD's Center for the Study of Constitutional Originalism, and of course will, I think, bring a different perspective, perhaps, than our first two speakers. And then finally, we have Jack Beermann, who's professor of law and Harry Elwood Scholar at Boston University School of Law. I got to know Professor Beermann when he was a consultant for the Administrative Conference on a project on midnight rulemaking. I was at ACUS for 5 years before I went into the academy. And actually, I think 4 of the 5 of us up here currently serve as public members of ACUS. No? 3 of the 5. I can count. So with that, I will turn it over to our first speaker, Chris Walker, and you have 12 minutes. I'm timing you.
All right. Well, it's so great to be here and to be here to talk about administrative law. There's not a better topic out there right now than administrative law. And I want to focus my remarks on modernizing the Administrative Procedure Act. And then in the Q&A, probably we'll go bigger than that and talk about the Constitution as well. But I want to start by talking about what Justice Scalia called the quasi-constitution of the administrative state, which is the Administrative Procedure Act. This was legislation that was enacted as a fierce compromise after 15 or 16 years of debates between Republicans and Democrats in 1946. In the past 7 decades since it's been enacted, it's been amended about only 16 times, depending on how you count. There have arguably only been 4 what I would consider major amendments: the Freedom of Information Act in 1966, the Privacy Act in 1974, the Government and Sunshine Act in 1976, and then I think also, and Katie's written about this a little bit more, in 1976, what I'd consider the fourth is the waiver of sovereign immunity and some of the other amendments that came with that legislation. So it's been over 20 years since Congress has amended the APA at all. I guess technically a couple years ago they did amend the FOIA provisions a little bit more to add for some more kind of online presence. But and it's been nearly 40 years since the last significant statutory change to the Administrative Procedure Act. Now, that does not mean that the Administrative Procedure Act has not changed. It's changed a lot. It's just that Congress hasn't been doing the work the courts have. And we have what has grown, if you read the Administrative Procedure Act and you don't look at the case law or you haven't taken administrative law, you're most likely going to get almost every issue wrong. Because of the way it's been interpreted through administrative common law. And I'm so glad to have Katie here because she's one of the leading scholars on this topic. But I just want to throw out a couple that you have. For one, you have judicial deference doctrines like Chevron and Auer that aren't in the Administrative Procedure Act. You have hard look review that's been grafted onto arbitrary and capricious review. You have remand without vacatur, that an agency, a court can send a rule back but keep it in place for the agency to redo it on remand. The court has basically eliminated formal rulemaking from the Administrative Procedure Act, and yet on the other hand, it has turned notice and comment rulemaking into basically a form of formal rulemaking, and that's stuff that's not tethered to the Administrative Procedure Act. You have John Duffy's written about exhaustion of administrative remedies. Kovacs has mentioned prudential ripeness doctrine that's not in the Administrative Procedure Act, and Nick Bagley's written on the presumption of reviewability, which is also not in the Administrative Procedure Act. So while Congress hasn't done much to tinker with the quasi-constitution of the administrative state, the court has done a lot, both the Supreme Court, the D.C. Circuit, and some of the other circuit courts. Modernization of the Administrative Procedure Act is needed, but it shouldn't be done by courts. Congress should play its proper role in regulating the administrative state. And you would think that perhaps in this current political climate, there might be an opportune time to do that. So what I want to focus on today is one of the pieces of legislation, the Senate version of the Regulatory Accountability Act that Senators Portman and Heitkamp introduced, along with co-sponsors Hatch and Manchin. And I want to talk about how I think if the Regulatory Accountability Act is enacted, and I think there is a chance, then I think that would be the most significant reform to the Administrative Procedure Act since it was enacted in 1946. And I'm happy to defend that claim a little bit later. And I want to say that I also think that this is what bipartisan legislative form should look like in administrative law. And I want to focus on three things today on why this is what bipartisan legislation reform should look like. And I've explored this in a lot more detail in an administrative law review essay that came out a few months ago. So the first is that the legislation's foundation consists of common sense, consensus-driven recommendations for how to reform the Administrative Procedure Act. Most of the recommendations from the ABA's administrative law section, a resolution from 2 years ago, are in the legislation. So, for instance, and these are also recommendations that the Administrative Conference of the United States, our federal agency that does research on federal agencies, if we don't need another federal agency, also is recommended for decades, a lot of these. So for one, it would require a public rulemaking record. Courts have basically required that, but that's not in the APA. It would require that agencies disclose all studies, models, scientific literature, and other information developed for or relied upon by the agency. That's something that courts usually require, but it's not in the APA. It would set a minimum comment period of 30 days for regular rules and 60 days for major rules, with an exception for good cause. It would address the growing concern about interim final rulemaking when agencies issue a interim final rule and then ask for comments on them after the fact. It would address Jack Beermann's favorite topic of midnight rulemaking, although maybe not the way Jack Beermann wanted to be addressed. And it would also codify procedures for retrospective review of outdated rules. These are all things that the ABA, our friends that are a little more left of center, have been pushing for a long time, and same with the Administrative Conference of the United States. It would also codify the best practices that the presidents since Reagan, Carter arguably, have been advocating on the executive side for review. It would require more rigorous economic analysis. It would codify a lot of Bill Clinton's Executive Order 12866, as well as President Barack Obama's Executive Order 13563 on economic analysis in rulemaking. So it adopts the foundation of this legislation is consensus-driven reforms that either courts have already embraced or that the ABA, ACUS, and presidents have been pushing for and using for decades. The other thing that it has is it incorporates a number of important bipartisan compromises. It's not a perfect bill. It's not the bill I would pass if I were the sole member of the legislature. For instance, Republicans for a long time have been calling for agencies to engage in more transparent and publicly accountable processes when making rules. And the legislation would require that, such as formalized and more public cost-benefit analysis I just discussed, opportunity for public hearing of disputed facts. So you have a little bit more of a formalized rulemaking return, but the compromise is that that's limited to rules that have at least $100 million impact on the economy. And indeed, the agency has a lot of discretion to deny formal, more formal processes up until the $1 billion range. So you see kind of this, and to kind of put this in perspective, the U.S. Chamber's estimates that there are only 140 rules of the 33,000 final rules that were promulgated between 2008 and 2016 that would fall into this category of $100 million or more. But it would require more formalized, cross-examination, a hearing, experts are, the facts and the science is going to be put under examination. I would note that just kind of pause there and think, the fact that we're amending the APA to recognize that agencies should be doing billion-dollar rules and do billion-dollar rules and $100 million rules, we're real far away from the original understanding of what agencies should be doing if we're up in the million, 100 million. And so in that way, it is a bipartisan compromise as well, that we are recognizing that sometimes agencies are going to do billion-dollar rules that arguably Congress should be the one that are legislated in the first place. There are also a number, if you look in the details of the legislation, I'm not going to spend too much time on this, but there are a number of other compromises. There's a good cause exception that's preserved, in fact, amplified for all of these procedures, so the agency can bypass procedures if they show there's good cause to bypass them. They use most cost-effective instead of least costly. Cass Sunstein, who came just short of endorsing the legislation, was a little bit puzzled by this in his Bloomberg View piece, and I'm still trying to figure out the difference there as well. There's a presumption of reasonableness if the agency considers 3 alternatives to a rule, another bipartisan compromise, and I think importantly, there's a savings clause in the legislation so that other legislation is not affected if it conflicts. The other legislation that preceded it will actually control. So those are kind of the, let me just talk about a couple more. It codifies hard look review, I think, my reading of but on the flip side, it also codifies remand without vacature. So you have it going back and forth as a compromise. And then lastly, and we'll probably talk more about the Separation of Powers Restoration Act, only a little bit of that legislation made it into the final rule. So Separation of Powers Restoration Act was going to get rid of judicial deference, period, for agency interpretations of law, both statutes and regulations. And what the Regulatory Accountability Act does is that it gets rid of it for regulations, for agency interpretation of regulations, in other words, Auer deference, but it preserves Chevron deference for statutes. And on top of that, it doesn't replace Auer deference with de novo review, but applies Skidmore deference, which is slightly less deferential. And I think this last move is important because the legislation does make it harder to make rules. And so one of the worries that you're going to have, at least that I would have, is that if you make it harder to make rules, what are agencies going to do? They're not going to make rules, they're going to make guidance, which is really easy to do. And by preserving Chevron deference, but getting rid of Auer deference would apply to guidance, Chevron deference would apply to rules. You're still trying to strike the right balance of incentives so that agencies continue to pursue rulemaking, which I think is in most circumstances, a much more ideal form of regulatory action instead of just going to the guidance process. Now I've got 2 minutes left, but luckily my last point is not the big one. So the first point is it's consensus driven. It's based on these ABA and ACUS recommendations. Second point is there's a lot of bipartisan compromises in the legislation. And the third point is the timing. It seems like in this political climate, we actually might be able to pass this legislation. Republicans in the Senate are still pushing for it. There's the Republican support there. The president seems to be not too concerned about giving away his power or making it harder for his executive branch agencies to work. And the Democrats, if the ASS panel yesterday is any indication with the title Never Ending Assault on the Administrative State, they should really want this too, right? Because it doesn't just apply to regulation, it also applies to deregulation. If these processes, how it's going to be harder for agencies to make rules, also apply to agencies making rules to get rid of rules. And I think that's a good thing. I think agencies should be much more deliberate, should be much more transparent, and should engage in reasoned decision-making and economic analysis when they're doing rules. And so if you're a Democrat in the Senate or the House, especially if it flips in 2018, and this seems like a reasonable way to make agencies more accountable and to slow down which way the agency moves, either in a regulatory or deregulatory fashion. So I'll end there, and Katie will tell me why I'm wrong. You can tell me I'm wrong. Oh, I'm never wrong. I like that.
Except when you are. Hi, Katie Kovacs. Thanks so much for the invitation to be here. Thanks to Emily for moderating. Thanks to all of you for coming out. I know it's the Cheerios that got you here, but I hope to be somewhat entertaining. So there have been a lot of proposals floating around to alter the administrative state. Some of these proposals have been around for decades. I want to lend some historic perspective to the discussion, focusing mostly on rulemaking. I think we need to stick with the APA. I think we need to update it for sure, and there's a lot in the Senate version of the Regulatory Accountability Act that's really pretty terrific. But we need to be careful not to overburden agencies. We need to be careful not to shift the balance that Congress and the administration and all of the other parties involved reached in the APA in 1946. Now, my views on this are, of course, arise from many years of being a government lawyer, but also from a stint last year at the Department of the Interior working on one of the rules that Congress promptly nixed under the Congressional Review Act. It's an interesting experience. So let's go back to the beginning. The Constitution doesn't say a whole lot about agencies, but they've always existed. 100 years ago, there weren't too many agencies, and the ones that existed didn't have much effect on people's everyday lives. Then along comes the New Deal. And suddenly we have tons and tons of agencies. And along with these new agencies came the question of how to control them. Now, remember what was happening at the time. In Europe, agencies were becoming tools of fascist autocrats. Stalin's show trials began in 1936. Kristallnacht was 1938. And here in the United States, there was a real fear that FDR would go down the same road. So the statutory history is riddled with arguments based on the need to avoid totalitarianism. That was the inspiration for the APA. Now, the American Bar Association, which at the time was a relatively conservative organization, led the charge on administrative reform. It really picked up steam in 1937 when the Supreme Court started upholding New Deal programs. Congress passed the Walter Logan bill, FDR vetoed it, then World War II came. Everything stopped for a while. But with the war came lots of new bureaucracy. I think there were 20-something new agencies related to the war effort alone that had a real effect on people's everyday lives with rationing and price controls and all of that. So 2 weeks after D-Day, the American Bar Association's draft bill was submitted in Congress, and it was designed to be a compromise between the conservative approach and the liberal approach. It passed unanimously, and President Truman signed it in 1946. Now, there was a lot in the bill that was controversial, and there were a lot of compromises. And so a lot of the language in the APA is murky at best, because that was the only way to pass a bill. And the RAA would be no different, for sure. But other things in the APA were quite clear. One thing that I wrote about earlier is that the same standard of review applies to all agencies. No agency should be getting super deference in this under the APA, and everyone agreed on that. Another thing that was pretty clear across the board was that rulemaking should be pretty simple, that a lot of the process should be left to agency discretion, because everyone wanted to encourage rulemaking. The idea was that regulated parties should have more certainty, and there was a concern about avoiding the separation of powers issues with courts making law. Now, since 1946, rulemaking has become quite difficult. The courts and Congress and the president and the agencies themselves have made rulemaking very resource intensive, which I can testify to from personal experience. So agencies try all these sub-regulatory approaches, guidance documents. That often doesn't work out so well for various reasons. So the effect is that it's really hard for agencies to make policy in a timely fashion. That is one reason presidents have started to make policy themselves more and more. Now, obviously, there are a lot of reasons why presidents take on a policymaking role themselves. Congress is usually stuck, to put it diplomatically. Presidents obviously like to take credit for policy. They like the publicity. And this is not a new phenomenon. I'm not dumping this on the current administration. President Clinton, I think, was really the originator of presidential policy making with his memoranda to agency heads. Bush, too, do you remember the whole flap about signing statements? Obama was a master of presidential control. But President Trump has really taken presidential policymaking and presidential control to a whole new level. Unitary executive theory is no longer a theory. This president acts on the premise that all executive power is vested in him alone, regardless of what statutes say. Now, on the one hand, this is good, because when the president makes policy, we are responding to an election. He was elected. He should make the policy, right? Okay, on the other hand, presidential policy making happens in a black box. It's not transparent. And the president does not get feedback from interested parties and affected parties to hone his policy. And just look at the immigration orders and how they've changed, 3 times already? And effectively, there's little democratic accountability when the president is making policy himself. When the agency is making policy through rulemaking, on the other hand, there is at least an opportunity for more deliberation, for more public involvement, importantly, for congressional oversight and judicial review, and it yields better policy by and large. The key is that agencies have to follow the rules, and agencies cannot be overburdened. Otherwise, we fall into the trap that the greatest generation designed the APA to avoid. And I don't think anybody wants that. So some of the particular proposals, I think, just need to be looked at with that in mind, that we need to maintain a balance. We need to make sure not to overburden agencies. So I wrote a little piece in the regulatory review about ANPRMs, Advance Notice of Proposed Rulemaking. I think they're a great idea. I think it's great for agencies to sort of scope out a rule before they make a formal proposal. I don't think it should be required across the board. The same for one that Chris mentioned. Online dockets for rulemaking are great. And it is certainly a lot easier to do this now, given technological innovation. But I don't think that we should require notice of all information considered in a notice of proposed rulemaking. In some circumstances, it would overburden agencies. It would inundate the public even more than we're doing now. It would give hyper-technical grounds for remand. As a practical matter, and again, I observed this in the agency that I was at last year, it would result in a lot of re-notices. So when an agency gives notice of a proposed rulemaking and then they realize there was something wrong with the notice, they need to give the notice again, and that simply delays the rulemaking even longer. And importantly, I think it would blur the line between formal rulemaking, which is on a limited to a particular record, and informal rulemaking, which is not. So I think the language of proposals like this simply needs to be tempered a little bit. We could look back on that point to the Attorney General's manual, which I often disagree with, but on this point it said the notice of proposed rulemaking has to be sufficiently informative to allow an opportunity to participate intelligently in the rulemaking process. There's some things in the House version of the RAA that are deeply problematic, I think. Other things that I think are no-brainers, like minimum comment periods. Congress didn't include minimum comment periods back in 1946 because they thought they could trust agencies to give a reasonable comment period. In the past year, it has become abundantly clear that that is not the case. The point of a lot of the proposals, especially in the House versions of the bills, seems to be to make rulemaking more difficult. That seems to be the point of a lot of these proposals. I agree that it would be far better for Congress to do its job. Congress should be making substantive policy decisions. And as Chris said, I don't think anybody in 1946 contemplated the scope of the rules that we have today. But if Congress doesn't make the policy, and it's been pretty rare that we've had a productive Congress. I think the first Congress of Obama's first term was pretty productive. Congress has certainly done a lot this year, but not in terms of making positive policy until quite recently. But if Congress doesn't make the policy, and Congress makes it impossible for agencies to make policy, who's left? Well, the president and the courts. I think the APA struck the right balance in 1946, and I think we should preserve that balance. And I'll stop there.
Thank you. Professor Rappaport?
Thank you. Thanks everyone for inviting me, participating. So the subject of this panel is reform proposals for the administrative state. And since I'm a classical liberal, I'm going to talk about classical liberal reforms. Now, there's a lot of ways to look at this question. The way I'm going to look at it is to ask what would be the best classical liberal institutions for administrative law, subject to a very important constraint, that these administrative law institutions be able to administer the large government programs that we have. Now, there's a variety of ways you could promote classical liberalism. Here I want to argue for a much more significant separation of powers approach to administrative law. Modern administrative law, as we've heard a little bit, since the New Deal especially, has moved towards a combining of executive, legislative, and judicial power in single agencies. But for me, that really creates a significant risk of government, improper government behavior, government wrongdoing. Defenders of the existing administrative agencies argue, oh, the traditional separation of powers would be inconsistent with modern government. And in particular here, the argument seems to be that there's a need for decision makers who have expertise and have the time to make the decisions in a timely manner to administer the administrative state. So these are the big two problems. I'm going to call them the expertise problem and the time problem. And while the traditional separation of powers, I think, may not be able to solve these problems in the present day environment, that's not the only alternative to combined powers administrative agencies. So today I want to sort of briefly talk about three reforms that I would recommend. The first is to adopt something like the REINS Act, which would have congressional approval of major rules, but with some reforms that I would add to it. Secondly, I think we ought to enact Article 3 administrative courts and have those independent administrative courts doing the adjudicating rather than agencies. And then thirdly, I think we ought to eliminate deference as to legal issues in the administrative agencies. So let me go into each of these. These ideas come out of a paper that I've recently published, and obviously I can't really do justice to it, so I'm just going to give you a kind of an overview of everything. So I guess the first thing to ask is sort of what's the argument for the separation of powers in the administrative context? And I think the way I think about it is, one way to think about the separation of powers is what would be the opposite of the separation of powers. And we could imagine a single entity having all the government powers making the decisions. And I think if you think about it that way, there's really little reason to think such an entity would lead to good results, right? We can all imagine that that entity might have a number of bad objectives and bad incentives here. They might want to promote the political party that they're in. They might want to expand their own power. They might want to pursue an extreme ideology that the public doesn't necessarily favor. Now, agencies are obviously not this entity. There are checks on agencies. But the movement from the strong separation of powers of the 19th century to the much weaker separation of powers that we have today has moved significantly towards that kind of model, although obviously only part of the way there. Agencies just have substantial discretion in a number of areas, in a number of different ways, to do the things that they want to do. Now, I think the stronger separation of powers in this area would place limits on the agencies, would promote the rule of law, and would improve their incentives. I'll try to get into that just a little bit in remaining remarks, but so let me first of all start with the REINS Act. You know, if the separation of powers is beneficial, though, would it solve the expertise and time problems that we have in various different areas? So you could start with agency rulemaking, right? And at present, agencies pass numerous regulations every year, and it would be extremely difficult for Congress, I think, to enact those regulations. First of all, they simply don't have the time to negotiate and enact those rules. And they also are unlikely to have the expertise to draft and enact those rules, right? But these expertise and time problems, I think, could be addressed through something like the REINS Act, through requiring congressional approval for major rules. So the REINS Act continues the existing system where the agency regulations are written, drafted by agencies. But for the most important regulations, what we call major regulations, they would be submitted to Congress for Congress to take an up or down vote on an expedited procedure which would limit debate, so sort of a fast-track procedure. So this arrangement, I think, addresses both the expertise and time problems. First, Congress would not need the expertise to write these rules. That would continue to be done by the agencies. They would only have to make the decision on whether to approve these rules, which I think actually requires far less expertise. Congress also has other advantages. You can call this expertise, or you can say it's a reduced bias, that outweigh any additional expertise I think that the agencies have. Now, there's a variety of them. Let me just mention two of them. First, Congress is a general entity, and they're therefore likely to avoid the kind of tunnel vision that agencies show, where they want to promote their area, which they think is the most important one. Congress balances those issues much better. Congress would also be politically accountable. They're less likely to exhibit an extreme ideology, which wouldn't be shared by the public. The second thing about the REINS Act is it would help address the time issue, right? So there's a limited number of major rules, depends on what period you're looking at. My sense is that they're between 50 and 100 per year, and Congress would have the ability to vote up or down on that number of rules in a year. I'm not sure they would want to, but they could do it. So I think while the REINS Act addresses the time and the expertise challenges, it does need some reforms, and in the paper I go into 5 reforms that I think are important. Let me just mention one here. So the REINS Act grants the OMB the authority to determine whether or not something is a major rule. Now, how to define a major rule is a sort of interesting question, but let's assume here, just take the definition where it's a rule that has an effect of more than $100 million per year on the economy. Now, allowing OMB to make this decision would be problematic. After all, the agencies and the president who superintends OMB are not going to want rules to go up to Congress for approval. And so you're really not going to be able to trust OMB to make that decision. Instead, what I'd like to see is to have OMB make the initial determination, but subject to a challenge in court, which would not give deference to OMB. But because the issue is a technical one, I'd like to see an independent Article III administrative court that has expertise in economics make that decision. Let me talk a little bit about those type of courts now, and talking about another aspect of administrative law, which is agency adjudication. Now, at present, agencies adjudicate a large number of cases. ALJs initially typically make the decision, subject to appeal by the agency. Now, to the agency heads. Now, while the current arrangement addresses the expertise and time problems, I think it creates poor incentives. An agency is both the judge and one of the parties to a case, right? So they have an incentive to want to promote their view of the case. If they lose before the ALJ, they just appeal it to themselves. This kind of leads to a situation where you have an incentive to have biased results, which is surely a problem. And it even actually gives agencies an incentive to bring even more questionable cases because they know they're going to be the judges of them. It's true they're subject to appeals to the courts, but again, the appeals involve significant deference to the agencies. So I think these poor incentives could be addressed by establishing independent Article III administrative courts, where judges would be, Article III judges could only be removed by impeachment. Their decisions would not be reversed by the agency. And these courts would address, I think, the expertise and time problems. The courts would need to be expert, but they could be. What I would do is I would divide up the judges into 3 different groups, each group having expertise in a different area of health issues, one group, another one economics issues, third group would be science people, and they would have both law and the other area of expertise. And judges wouldn't be assigned these cases from a single agency, as they are now. ALJ is a part of the agency, which promotes a kind of tunnel vision. And instead, they would be assigned issues based on their expertise. So economics issues would go to the economics judges. So I think these independent administrative courts, 1 minute left. 2, 1, could also solve the not merely the expertise issues, but also the timing issues. Even though these are Article III administrative judges, Article III judges, there is no reason why we couldn't use a lot of the streamlined procedures that administrative adjudication uses today in order to decide a large number of cases. All right, well, I only have probably 30 seconds left, so I'll just say the third part of this is I think we ought to eliminate deference as to law interpretation, Chevron deference for statutes, Auer deference for regulations. I'm really crazy. I think we ought to eliminate Skidmore deference. Most people who argue for eliminating Chevron and Auer argue for retaining Skidmore as I guess the the bill that Chris was mentioning. The basic argument here is that I think federal appellate judges have the expertise to interpret statutes. These are legal issues, they're not policy issues. And I suppose one way to think about it is, if federal appellate judges are not good, not adequate, don't have adequate expertise if they're not good at interpreting statutes, what are they good at? Right? This is a core area for them, and I would like to see them making the decisions on what the statutes mean rather than the agencies.
Thank you, Professor Rappaport. And finally, we'll hear from Professor Beermann.
Thank you. Well, having the ability to go last means I can comment on what some of the other people have said. And I would say I found something that in Michael's presentation that I agreed with, which is it's crazy to eliminate Skidmore deference, so you are crazy. But I would... Thank you so much. You're welcome. But I just want to start by saying that a lot of these reform proposals are obviously, to anyone who's really paying attention, efforts to slow down regulation, minimize regulation. And if you look around the world and look at the history of a country like ours, regulation is actually what makes the country and the economy hum. And in our country, it protects hundreds of millions of people from bad air, bad water, bad food, bad drugs, Ponzi schemes, things like that. And if you look at the world and see where there are countries with failing economies, they tend not to be the economies with a lot of regulation. They tend to be low regulation countries where economic development is stymied by the fact that there's no reliable structure within which to build an economy. So this is an effort. The reason that these reform proposals have come up is an effort at redistribution of resources from the many to the few. And so what we're seeing is a very strong movement, especially since the unleashing of money that the Supreme Court decided was appropriate for our political system, toward pushing the benefits of the great bounty of this country toward the few and away from the many. So now the question is whether Congress is really going to pass these kinds of reforms that are going to do this. And one of the issues, of course, is that Congress has a great deal of interest in perpetuating the administrative state. It's a great source of patronage, and it's the way that, as Fred McChesney explained so well in his work, it's the great way that interest groups are provoked to contribute money and other services like employment and things to the people that are in charge of government regulation. And so, as Adrian Vermeule said in his recent book, if somehow the Congress really destroyed the administrative state, it would just come back in some other guise because Congress has too great of an interest in perpetuating it. So I'm going to go through. My task here was to go through some of the specific proposals. So that's what I'm going to do. And Chris, am I correct that when you talked about the focus on Auer, that's in the Senate bill, but not in the House bill that was passed, correct? The House bill retains the original Separation of Powers Act. And so its question is what's going to happen if they actually both pass a bill, right? Am I correct about that?
Well, I mean, with any regulatory reform, the Senate bill is the only thing that matters.
Okay. So so I'll start with the REINS Act, which
Maybe
I think
that's
is...
because I spent some time in the
Okay.
Senate. It might
Yeah,
be
I got you.
biased, but
I
I
got
don't
you.
think it's a bias. I think the Senate bill is really all that matters.
I actually think that we can help understand the REINS Act if we understand the public choice aspects of all this. And the REINS Act, in my opinion, is maybe the worst idea to come out of Congress since the Alien and Sedition Acts. And but that's not surprising because Congress currently is one of the worst institutions in the Western world. It's populated by despicable human beings who, and as my favorite example in the recent tax bill, a member of Congress, it was okay to stand up and say, I won't vote for this bill until my business gets more of a deduction. And he succeeded at that. That's the Congress we have now, where it's okay to actually say, my economic interests must be furthered or I won't vote for a bill. Now, if that's who you want controlling the administrative process, that's like picking the drunkest guy at the bar and giving him the keys at the end of the night. So I would be very hesitant to think that we should do anything that Congress said at this point. Now, of course, the problem is that by comparison, the person presiding at 1600 Pennsylvania Avenue seems even worse. And I want to quote a tweet that was published in the New York Times actually by Peter Weiner, who said after the president unleashed his New Year's tweet storm, Mr. Trump's recent Twitter storm interviews are more evidence We're watching an American president psychologically, emotionally, and cognitively decompose. It's rather alarming to watch, and the president is not well. But at least he's cutting regulations. And I think that's where we are. So we have to think about these things in terms of a situation where this current person would not be president. The same way I once had to read for law review research, I had to read debates in Congress over some presidential powers in the mid-1860s, and the members of Congress kept reassuring each other that Andrew Johnson would no longer be president when this was going to be administered, because they were trying to kick him out of office at the time through impeachment. But the REINS Act, as we know, would basically require congressional approval to pass major rules, and it would significantly slow down the administrative state. But the reason that Congress might actually be in favor of it is because imagine what would happen, for example, if the FDA was considering a major rule regulating drug manufacturers or medical device manufacturers or something like that. The amount of money that would start flowing towards members of Congress about whether to pass that or disapprove that in the process would be astounding. And so you're basically, what Congress is doing with legislation like the REINS Act is trying to optimize the amount of support that they can get for remaining in office by having more pinpoint legislation like that. So you have a particular rule, all the people who would suffer under that rule will have a huge incentive to start lobbying about that rule, and the way the lobbying system works today, with the lack of any sensible limits on campaign support, you'll have just a massive inflow of money from the more moneyed interests, and so you'll get it's Congress's it's the bonanza for Congress that public choice theory predicts will happen when you have a threat of any sort of major regulation. So I think that that's what the REINS Act is about. It's not about actually doing anything in the public interest. It's about maximizing Congress's influence over the regulatory process in order to maximize political contributions. Now, the Regulatory Accountability Act is a much more wide-ranging provision, and I'm much more familiar with the House version, which I've just found out doesn't really matter because Chris didn't work on it. So, but it wouldn't really fundamentally change the structure of the administrative state. But its most significant structural change would be to codify centralized review of agency rules by OIRA, which up till now has been in the control of the president. And this act would place some legislative requirements on that, and it would substantially increase the procedural and analytic requirements for making rules, that's the idea of minimizing regulation. It has nothing really to do with making better rules. The current system does a pretty good job of that, but it would actually slow it way down. And when you increase analytic and substantive and procedural requirements, and also things like mandatory lookbacks, without increasing the budgets of agencies, you know what they have to spend their time doing. They have to spend their time and resources doing something, and so they're not going to be able to devote it to making rules that protect the average person. They're going to devote it to revisiting rules or engaging in the analytic requirements that Congress is requiring them to do. Now, I think that OIRA review has improved the quality of rules, but sometimes it's obstructed good regulation. For example, in the massive slowdown that occurred during the Obama administration, when rules seemed to go into the black hole of OIRA and disappear, never to be heard from again. And I think that shows that codifying that would, in my view, would actually exacerbate that, unless the codification contained really strict time limits, so that a rule would automatically leave OIRA after the time expired. The way the presidents have, and especially President Obama, administered OIRA, the time limits were not relevant at all, and the regulations just died there. So I think that that's the only way that I would think that it would be proper to codify anything about OIRA would be to codify the time limits, so that the rules could actually get out of the agency. Now, one of the whole things that I really agree with is the Regulatory Accountability Act's prohibition on deference to guidance. Guidance has definitely been abused, but I think it's important to remember that guidance is actually generally a good thing. It's better to know in advance, if you're a regulated party, how the agency views what the regulations and statutes require of you. So it's a little bit of a conundrum. On the one hand, you want the guidance because you want to know what the agency's up to. On the other hand, you don't want the agency to be able to skirt the rulemaking process in order to and issue guidance that then has the effect of law. But I think what you need to do is you need to try to cabin the abuse without taking away the positive effects of guidance, which is to let people know exactly what the best way that they could follow the law. On the House version of getting rid of Chevron, I totally disagree with that. Although not getting rid of Chevron, I've published an article explaining why Chevron ought to be overruled, because I think it's turned out to be a very poor decision procedure. If you recall, it was a conservative push to make it easier to get deregulation during the Reagan administration, and I think it succeeded in that in a certain extent, but it's been generally a failure as a decision procedure, mainly because it doesn't actually have any discernible content any longer. Basically, anything can either be overruled or pass Chevron review. But I think there ought to be deference under the Skidmore factors for all of the reasons that Skidmore makes sense in terms of agencies knowing much more than courts about the regulatory process. I mean, Michael may be right that judges do know what statutes mean, but I don't think that they're necessarily better than agencies at figuring out what the best policy is to pursue when there's an ambiguous statute, which is what really deference is all about. It's not also the title, Separation of Powers Restoration Act, always bugs me, because there is no constitutional requirement for judicial review of agency rules, so I don't see how it restores anything related to the separation of powers. The last two things that I'll talk about in my limited time are the requirement that any interested party can get formal rulemaking on any major rule. That's obviously just an effort to stop the rule from going into effect. It's just a disastrous procedure that has been largely abandoned by agencies insensibly because it was just a failure. It doesn't actually produce better rules or better considered rules. It just creates a huge amount of time sink and resource waste. And the other crazy provision in the Regulatory Accountability Act is the provision that requires agencies to stay the effective date of major rules whenever judicial review of them is sought. And that seems to be unbelievable, that you would give a single person or a single entity the power to stop a rule for years from going into effect. And the reason that I want to explain the framing of all this, the rules that agencies have promulgated over the last 40 years or 50 years since we've had major reforms like the Clean Water Act, the Clean Air Act, the OSHA Act, and all that, those have been massively socially beneficial to this country. The gains that our society has made from these rules is unbelievably high. The problem is that they have distributional effects that run counter to the people in control of our political system.
Thank you, Professor Beermann. Now, just to make sure that everything is fair and equitable, we will have a little time for the panelists to respond to each other. So if any of you would like to do that, now's the time.
Well, I'll jump in. So, I mean, with respect to Jack's remark, so first thing is, sometimes you're accused, if you're a critic of the administrative state, of being too extreme. Agencies don't make all the decisions. But I think Jack made it really clear here. He doesn't want Congress doing anything, right? Congress is crazy. Congress is corrupt. Wants the agencies making the decision. So that's fine. It's out there on the table. With respect to Congress, actually, I have a very different view on the REINS Act. I don't think Congress wants the REINS Act. Jack says, they would want it. That way they would get a lot more campaign contributions because they would be important. I actually think the reason we get delegation from a sort of congressional perspective is they don't want the responsibility of having to vote on these matters. They don't want to have to deal with these issues. And so whereas I propose the REINS Act, I think it would be an improvement, I'm not optimistic about seeing it getting enacted. And because the last thing the world Congress wants is to be forced to vote up or down on a clear issue. I guess just on the last thing, I should sort of briefly explain maybe why I think Skidmore is a problem. Skidmore deference is the idea that an agency is not entitled to the deference, but that it can exhibit its expertise in the way in which it reasons about either a statute or a regulation, and so if it behaves like an expert, it should be given deference. The first problem with that is it's a bias, it's a government privilege, right? So if the private party, through the submission of their briefs, exhibits expertise, they don't get Skidmore deference. If the FCC takes action and they seem like they're an expert, they get deference. But if Verizon, who's involved with communications issues all the time and has communications lawyers, does something like that, they don't get deference based on Skidmore. So it's a government privilege, and in a way you really don't need it. If you're looking, if you want to see how persuasive something is, part of the persuasiveness of it is whether it seems to exhibit expertise. So you just have judges looking at the submissions from the parties. That way they can give a sort of equal playing field to the government and to the private party.
I want to make 3 quick points. One, you all should read Philip Haberger's Is Administrative Law Unlawful? You will probably disagree with most of it, either because you're a unitary executive fan or whatever. But and most people disagree with most of it. My initial impression was this is not the administrative state that we have here in the United States, having spent a lot of time interviewing and surveying agency officials and working with agencies. But then I hear Jack Beermann today, and I read Jillian Metzger's Harvard Law Review foreword, where she says that not only is the administrative state constitutional, but it's the current one we have is constitutionally obligated, that we have to have the current version. And I'm worrying a lot more, and I probably need to go back and reread Philip's book. So that's point number 1. Point 2 on the REINS Act. I don't know where I'm at on the REINS Act. I don't think it's a good idea. I don't think legislation will be passed. I think that the rulemaking will really bog down the rulemaking process. But beside that, like the Congressional Review Act, and Ron Levin and I have talked a lot about this is a reactive Congress. We need a proactive Congress. We need to be demanding that Congress actually pass legislation. And one way to do that is to get Congress back to its normal process of reauthorizing the organic statutes that control agencies. The Farm Bill is a great example. It's reauthorized every 5 to 7 years. All the stakeholders come to the table, they review the act, they figure out what's going on in the future. Most of the agency's organic statutes are supposed to be reauthorized every 3, 5, or 7 years. It's in the statute. But they don't. Instead, they use the appropriations process to continue to fund stagnant or stale substantive statutes. I think that's one point. And the third point on Skidmore, having read over the last few years with Kent Barnett thousands of circuit decisions that involve Chevron and Skidmore, it's just, they're not really legal questions. I mean, yes, once you get to step 2, the court's admitting that there is space for the agency to play. And if there's space for the agency to exercise some policy, when I say the agency, that's the president as well in many cases. If there's space for the agency to play, the agency has expertise. And when I say expertise, they were there when the statute was drafted. They are communicating with Congress constantly about their statutory mandates. They helped draft the statute. So on that side, they actually know the statute. And I think more importantly, they're the experts of their own regulatory scheme. And so I have a hard time saying why Skidmore should fall if we get rid of Chevron. I don't think that a private party has the same type of intimate understanding of what Congress intended when it passed the legislation, when it left a space, an ambiguity. When it didn't leave a space, I completely agree with you. And apparently, Judge, who's the judge that just published the essay? Oh my goodness, why am I blanking? Sixth Circuit. Judge Kethledge just had this essay where he says he's never gotten to Chevron step 2 in 10 years. He has never found a statute ambiguous. That's amazing. Absolutely amazing that no statute, having just read thousands of these myself, cases, I mean, that's a pretty amazing claim. But I think that's the move that those who want to get rid of Chevron should make is to make a more robust step one.
I just feel obliged to give the House credit for these fabulous acronyms. I think it's them.
The House comes up with the names.
The REINS Act is REINS, like Congress taking the reins. What is it? Regulations from the executive in need of scrutiny. Right? They've got some fabulous acronyms. But I actually really like the idea of the REINS Act, of Congress taking the reins. Let's make Congress do its job. That's fabulous. I'm glad to hear it won't pass, though, because I think the effect, I think Jack mentioned this, that agencies simply won't engage in major rule making because they would be afraid of wasting the time and the resources. Why would they spend, it takes years to write a rule. And then OIRA, what a nightmare, which does, in point of fact, provide a generalist review, which was one of Michael's concerns. But agencies already avoid major rulemaking because OIRA review is so difficult. They already piecemeal, and again, this is from personal observation at Interior, they piecemeal rules. Instead of engaging in a more holistic, wide-ranging rulemaking, they'll break it up into segments to avoid OIRA review. For sure, they would do that even more if the REINS Act were to pass. I do not think it's a good idea. My preliminary view about eliminating Chevron is that it probably won't change much. Because of what Chris was just saying, that Scalia's legacy on statutory interpretation is that judges are more and more likely to be perfectly capable of interpreting a statute. Thank you very much. They pull out the dictionary and they know what it means. So we just don't get to step two as often as we used to under more traditional or old-fashioned modes of statutory interpretation. And these days, step two, if they do find the statute ambiguous and get to step two, that's just arbitrary or capricious review, which isn't going away. So I eliminate Chevron, I'm not sure it would actually do much. And I think as a practical matter, if you were to try to eliminate Skidmore, it wouldn't go anywhere either. They just wouldn't cite Skidmore anymore.
So I just want to, can I make a couple quick points? I agree with Michael, by the way, that I don't think they want the REINS Act. I was trying to give some reason why maybe they would. That's how when I began talking about how it would what it would provoke that would be beneficial to them. I was saying that this is maybe a possibility of what they might want. I mean, I think that avoiding responsibility is maybe outweigh that. I'm not sure, but I do also. There's also other puzzles about the REINS Act that have to do with what happens to judicial review then once Congress has approved it. But that's a completely different question. The other the thing about my views about Congress and wanting the agencies to do everything. I'm talking about the current Congress. I think we're at the potentially at the precipice of a major disaster for our government because we basically have. We've unleashed this notion that self-interest is really the thing that you're in government for in a way that I think it's always been the case that members of Congress are out for themselves, but I don't think it was ever proper before for a member of Congress to stand up and say, I won't vote for this bill unless my business gets more money out of it. I just don't think that was proper. And I think it's become proper, and if that culture sticks, then we do have a major problem with Congress. And I'm hoping that that what's going on in the government today will that people will see how disastrous it is, that maybe that there'll be a strong enough pushback to end that sort of thing. But for now, I'll take the product of other Congresses, that is all these regulatory statutes that have been passed and administered for the last 50 years that in my opinion have done a pretty good job of making this country great already. And so it's a problem of who the current Congress is. What the ethics in the current Congress have become. And I think that's the main important thing is that, of course, all of this happens under instructions from Congress. The best explanation for why the administrative state is not a violation of separation of powers and why it is a perfectly normal way to think about the government is in Chief Justice Berger's footnote 16 in the Chadha opinion, where he explained why bicameralism and presentment are not necessary for agency rulemaking. And I think that he explains it, and the thing is that agency rules are always been subject to limits based on what Congress has set forth, and they've always been subject to judicial review, and that safeguards the system in a way, and there's no separation of powers question about the constitutionality of the administrative state that's at all a legal question anymore, except in people that don't like the way that American constitutional law has gone for the last 100 years. And I think that Philip Hammerger's book, if you want to read a fantasy account of the U.S. Constitution and administrative law, I would say read that book, because it's a fantasy. It has no connection at all with any reality.
Yeah, I just want to make one just brief point about deference. So Chris says, well, look, in Skidmore and in these other cases, deference really involves sort of a policy issue, because once you get to Chevron step 2, Congress hasn't spoken clearly. And I just disagree with this as sort of a fundamental premise. If you think about a statute that comes up in a non-administrative context, if the statute is not clear, judges have a variety of tools. What was the underlying purpose, the structure, a variety of things that they look to in order to resolve that ambiguity. And the way they're supposed to resolve that uncertainty or ambiguity is not by figuring out what they think is good policy, but by looking to these things like structure and purpose. Suddenly, when it's in the administrative context, it's redefined as a policy issue, and then the agency gets to decide it as a policy matter. I just think that's a fundamental mistake. What we need to think about is that these are all legal questions. Some are close legal questions, that's step 2, and some are clear legal questions, that's step 1. And so you don't need to think about these things as a policy matter, and I think they're best thought of not as a policy matter, but as a legal issue.
Great. So since we have such wonderful, concise, punctual panelists, we have a good amount of time left for questions. There's a microphone here in the middle, and so I'll go ahead and open it up.
Hey, Michael. This is for Mike Rappaport. So do you think that Congress... Oh, sorry, is this not on?
No, it's on.
It's on, okay. Do you think that Congress cannot leave policy-making details to the executive branch? Because it seems to me that that we do think that part of the reason we elect a president is in order to let him determine some aspects, at least, of domestic policy, including in his cabinet appointments and so on.
Well, I think the cabinet appointments are another matter, but if you're asking whether or not it's okay for the executive branch to exercise policymaking authority, so first of all, I should make clear, even though I write a lot about originalism, none of this is an originalist analysis. It's a sort of separation of powers analysis. You could disagree with my version of the separation of powers, as of course some do. But so, yes, I think that Congress, under my scheme and given the existing administrative state, yes, I would recognize that Congress does and probably needs to leave policymaking to the agencies. What is the check on that? Well, with respect, there's a bunch of different things, but with respect to major rules, Congress gets the approval or the disapproval. With respect to non-major rules, then I don't have much more to say other than that we should employ hard look review. So it's going to happen. I recognize it's part of our existing system. I just want to have an additional check on it in the form of major rules.
Okay. Yeah. All right. But
I wish we could do more, but under our existing arrangements, I don't think we can.
Right. No, so I guess, yeah. So then, I mean, it seems to me that the whole critique of Chevron, if you reformulate Chevron so that instead of saying we defer to the agency's construction, the decision were written as we recognize that Congress has delegated policymaking to the agency. If there's not a clear way, if we can't sort out the ambiguity, it seems to me the whole criticism almost goes away, and then it just becomes a matter of how hard you work to resolve the ambiguity before you reach that conclusion. But or maybe you should just be asking the question more directly, has Congress delegated this policymaking authority to the agency, rather than asking the question, does the agency have, quote, the authority to resolve the ambiguity?
Right. So the first thing, so there's a lot of ways to improve upon Chevron. The biggest problem of Chevron is that it assumed all ambiguities, or some variety of ambiguities, were intents to delegate, and which is, I think, completely unjustified. In fact, the Chevron decision itself recognized that when Justice Stevens says sometimes they haven't even thought about the issue, but that's obviously not an intent to delegate. So you could just look at and have Chevron operate, by looking sort of implicitly, did Congress intend to delegate this? I think it's actually better. I would prefer an arrangement where we assume, unless Congress actually says so, and it actually does say so, that you would treat this as not involving a delegation. If that's too much for people, you could have the old system where you have pure questions of law don't involve delegations, and mixed questions do, right? So that'd be another way that you could deal with it. Anyway, I don't know.
Okay, great, thanks.
Your second to last one was the law before Chevron. If they used language like "as defined by," then they got the extreme deference. Otherwise, it was normal judicial review.
So
And I should say, I've disagreed with Jack quite a bit. I very much like his anti-Chevron paper. I recommend it to everyone.
I want to jump in here and provide a little bit more kind of the empirics. So Abby Gleck and Lisa Bressman, I don't know if you read their survey, but and then my follow-up with the agencies, this is the game. Ambiguity, Congress knows they're delegating, and agencies know they're getting the policymaking space. And so maybe that's not like in the statute itself, but that's the backdrop norm since 1984. At the circuit court level, it's kind of interesting. In our 11-year data set on Chevron cases, courts decided the question at step one 70% of the time, and agencies won 40% of the time at step one, so under de novo review. In the 30% of the cases where they got to step two, agencies won about 94% of the time. And so step two doesn't really play much of a role in providing a check, but there's a pretty robust step one check there. And again, these are really, I don't know, like if you read these cases, the ones that make up the circuit courts, they're really mixed questions of law and fact that get to step two for the most part. They really are, different. And then the last point I'd have is maybe you like the Judge Kavanaugh's attempt to rework major questions doctrine to basically say any legal question that implicates a major economic issue, maybe $100 million or more, doesn't have Chevron. Maybe that's the way you want to go. I think that's kind of a cool proposal. I haven't seen that pushed yet. But this idea that the major questions doctrine actually has a threshold. Actually, I think that might be in Steve Calabrese's memo.
And just one little note from Chris's comments. When we're talking about administrative reform these days, we don't need to be guessing. We don't need to be working on theory. We do have the capacity to do empirical research in administrative law now. Lisa and Abby's paper and Chris's work are just remarkable in the insights they provide as to how administrative law actually functions in the real world. I think we need to put more of an emphasis on empirics when we're talking about reform proposals. But don't ask me to do it.
I have a question for the panel inspired by Professor Kovacs' remarks. First off, I think there's going to be a panelist with the conference later today. John Yoo is going to be very happy to hear that the unitary executive theory is actually come to fruition. But that I don't think was just invented by John Yoo personally. I think it kind of actually goes back to what Alexander Hamilton talks about in Federalist 70, to have one person in charge of the executive branch brings accountability. And that's, I think a lot of the Trump reaction to the administrative state right now is that it's not being accountable to the people. And your remarks, you said, well, these agencies have gone back to the beginning of the country, but not all these types of agencies have gone back to the beginning. Independent regulatory commissions, you don't have those. You have the post office, but you don't have those. And And so I think there's some types of agencies that the American people have a big problem with the way they're operating. And my question is, why aren't these agencies being considered for just elimination? We have in Texas a Sunset Review Commission. They don't get rid of that many agencies, I don't think, but it seems like that's what, some of the force of the criticisms of Trump would be going toward. And has that been considered in an attempt to drain the swamp?
Yeah, I mean, I think you're absolutely right that a lot of what is going on right now is refighting the New Deal. That a lot of proponents of regulatory reform, as Jack said, are really just trying to shut down regulation. It would be more direct to simply get rid of the Social Security Administration. Obviously, that's not going, I think it's obvious, I hope it's obvious that that's not going to happen. I like Bill Eskridge's super statute theory that some of these statutes have just become so entrenched in our law that we're not going to be able to get rid of them at this point. So I think that's why we're seeing such an attack on the administrative state. It's really an attack on the New Deal, I think.
Yeah, I would just say which agencies should get eliminated. What are they doing that's causing costs on the economy that are greater than the benefits? I don't know of those agencies. I think that in general regulation has positive social costs, and so if you get rid of agencies, basically you harm the country.
So, we could debate these issues, whether, we need all of these different agencies doing the various different things. I think that's a sort of I'm going to treat that as a separate issue. The basic point of having these reforms, I think, is to say that given our existing system, what checks do we want on the agencies to make sure that the regulations that they do enact are public interested ones? And my take on all this is that they have a lot of authority. Some of the regulations they pass make sense. Some of the regulations, even the ones that make sense, go too far. A lot of ones don't make sense. And I'd like to try to have some kind of reforms that pushes us more in the direction of promoting public interested regulations and less towards the more harmful ones.
I'll just make a quick point on the unitary executive. I mean, when that was, we're assuming there's a functioning Congress and a separation of powers where, I think that's something that we're seeing is, we need to be thinking more about Congress's role, in the process, both as an oversight, but also as the one that's providing the source of law that the president is using through agencies. So I think that's like what's different today in the current administration. One of the things is you might have a stronger president exerting more executive power. You have a Congress that is not playing its role, and I think that's an area where if it were playing its role, we'd have less of a problem with Chevron deference if Congress were legislating, and I think we'd have less of a problem with how the executive's acting more generally if Congress is overseeing.
I think there's actually a connection here. It's not the only thing that's going on, but with the political disagreements and the fact that the Congress can't work together is not unconnected to the fact that agencies have all this authority and can basically act. So if you interpret statutes to allow agencies to address new problems that were never envisioned, basically the executive branch can operate on its own. And the people who like the president's activities are not going to want to do anything about that. So they're going to be dug in. And the people who don't like it are going to want to change that, but they're not going to be able to do so unless they control all the three branches. If you imagine a world where agencies don't have all of this power, it actually requires Congress to act. And you create incentives for Congress to then have compromise, have relationships across the political parties. And that's exactly what delegation has not incentivized. It's caused Congress to not need to act, to posture, to disagree with one another. And so I think there is a connection here between delegation to presidents and the lack of a functioning Congress.
Ron Levin, Washington University School of Law, notorious anti-administrativist. I have thoughts on a number of issues that the panel raised, but I want to say initially that I know Chris mentioned his agreement with me on the desirability of having a more proactive Congress. We do agree on that, and I would add that another step in that direction would be, a very simple step, would be for Congress to restore the resources that they devote to staff, which has been drastically cut over the past several years. And one reason why they delegate is they just don't have the capacity to make internal policy. They can vote on things, but they don't have the expertise internally to think about it very much, so they become dependent on lobbyists or on the agencies. And if the goal is to have more role by the legislatures, then let them build up their capacity to make those decisions themselves. Now, I wanted to take Chris to task a little bit on one or two things he said. He has described the Regulatory Accountability Act as a bipartisan measure. In his regulatory review essay, he described it that way 7 times, and you know how long a regulatory review essay is. So I don't think that was just casual. But as he well knows, there are only 2 Democratic sponsors of the Senate bill, only one on the committee and one outside the committee. So if you want to make it really bipartisan, would it not be a good idea to drastically scale back the various measures in this act so as to attract the kind of two-party support that leads to stability and durability? And on a more specific level, in the same vein, Chris mentioned that one of the things the bill would do is to codify executive orders like the 12866. And I think that's not precisely true because although they pick up a lot of those provisions, they also make them all judicially reviewable. And that opens up the field to many challenges based on failure to comply. If the goal, as proponents have often said, is to simply codify those orders, wouldn't it be a fine idea as one of the low-hanging fruit to provide that all those codifications of 12866 and the like are all judicially unreviewable, although the products of the analysis go in the record as they do now? Wouldn't that be a simple way of promoting bipartisan reform as opposed to one that is characterized as bipartisan for public relations purposes, but is in fact a hard right proposal? Not to be argumentative.
So I like this. On the first point, I was on a panel with the general counsel of the senator, and she kind of echoed Ron's theme about the lack of resources of the Congress, but she made a different point, which I thought was interesting, was how much less they get paid than agency officials doing the exact same job, and how many people they lose after 3 or 4 years to the agencies. And I think that's interesting as well, not just the resources, like do they have enough staff in Congress to do what they're supposed to be doing, but are they going to be losing people? I mean, I know they always lose people to the private sector. I had not fully appreciated actually losing people to the agencies, and that has some pretty interesting dynamics there. As for the Regulatory Accountability Act, you know, in this Congress, if Rachel Brand can't get one Democrat to vote for her, I'm sorry. I mean, this is bipartisan. Any normal Congress, you'd have 13, 14 Dems lined up. The bill might look a little bit different, I agree, if they'd even come to the table. And trust me, we tried to get more Dems, more of the moderate Dems to come to the table to even talk. But the Democratic agenda in the Senate these days is to do no legislation. And that's fine. I mean, I understand that's the political climate. But to call the bill not bipartisan when the vast majority of what it does is incorporate stuff that we all at ACUS and the ABA have been pushing for decades, I think is a little disingenuous just because this Congress is not bipartisan, right? Now, as to the specific points, You're right. There's judicial review. When I said codify the executive orders, I meant some of the best practices in the executive orders. The judicial review remains the same. It's hard look, arbitrary, and capricious review. But now you also have, did they look at reasonable alternatives and the like? I think this is all great. Ron and I disagree on that. I think that courts should play a meaningful role in making sure that agencies engage in reasoned decision making, that when they're doing economic analysis, they actually do it right, that they consider reasonable alternatives, and that parties have a way to go to courts, especially for rules that cost more than $100 million, which is where you have most of this more rigorous analysis or economic analysis that's required. This is good things. So we can disagree on whether it's good or not. I think it's great. On formal rulemaking, that stuff we're probably more in agreement. I am worried that it will lead to ossification and the like. But as for the economic analysis points, I think that's the type of thing that a bipartisan Congress should embrace. And if it switches over at the end of 2018, I wouldn't be surprised if the Senate is more excited about making deregulatory actions more engaged in more rigorous economic analysis to make sure they actually get it right. You think about the Obama administration at the end of their term, the rules that they made have thick records with a lot of evidence in them, a lot of economic analysis. We're thinking Clean Power Plan or the like. If you want to undo those rules now, the Regulatory Accountability Act would make sure that the agency has to justify more fully its change in position, has to demonstrate with an empirical record that the Clean Power Plan, for instance, is not the approach that should be taken. And so I don't understand why more Democrats aren't jumping up and down now, wanting agencies to have to, and wanting courts, not Naomi Rao at OIRA, but courts being able to enforce whether the agency actually engaged in that economic analysis. I don't understand why this isn't a bipartisan issue.
One quick point. I agree with Professor Levin that it'd be good to have Congress having more capacity in this area. One of the things that's been proposed that I'm sympathetic with is, just as there's a congressional budget office, we ought to have a congressional regulation office that can provide the Congress with analysis of the regulations and do a variety of things which would increase their ability to act on these things.
The states have these offices called the Joint Committee on Administrative Rules or Rulemaking, and many states have this, about 20, and they have staffs that do analysis of all the rules that come out of state agencies, and that works pretty well. So that's something. I just want to say something about the Clean Power Plan thing. But the reason, if you notice that the rescission rule only says that the rule was illegal, it doesn't make any claims about the benefits, because they know that if they actually had to get into the costs and benefits, it's such a wildly socially beneficial rule that they could never get the repeal sustained on judicial review. So they're just saying that it's that there's no legal support for it. And if they lose on that, I assume under Chenery, that means they lose. They can't argue policy when their only basis for repealing the rule is law.
They would lose the first round.
Then they'd have to come. Then they'd have to actually do the work to make the policy, which it's hopeless because it's such a socially beneficial rule.
All right, we've got about 6 minutes left, so I think if we are expeditious, we should be able to get our two remaining questioners in.
Thanks for a great panel. So my question is primarily to Chris, but also to Katie. And Chris, you talked, I think one of your comments was about agencies engaging, the reforms being good because it would help agencies engage in more reasonable elaboration. It'd be good for the public because the public would have access, for example, to studies that then the public could comment on, and the courts would be able to use that record for its evaluation. And so I guess what I'm wondering, though, is how frequently are the criteria and reasons for rules publicly accessible and be able to engage in a neutral way by agencies, courts, and the public? What I have in mind was brought to me by an example where my brother-in-law, who I'm from Iowa, runs a livestock and agricultural commodities trucking business. And the Department of Transportation recently imposed a rule requiring electronic records. And the practical effect of it's going to be is that it's going to put him and other small family businesses like his out of business, likely. And from his perspective, he wouldn't challenge the Department of Transportation's claim that the electronic recording is going to save lives because it's going to make truck drivers drive less and therefore be less tired. But I think what he would claim would be that that there's not a neutral way to evaluate that cost compared to the cost that he identifies, right? So now there'd be increasing entry barriers to family businesses. There would be increased government regulation and surveillance of small family-owned businesses. And so what I'm wondering is, for Chris and Katie, how widely generalizable is the phenomenon that the costs and benefits are incommensurable, for at least from my brother-in-law's perspective? And if those kind of costs and benefits are incommensurable, then doesn't that argue in favor of Michael's position, which is that other branches like Congress should be the ones making these kind of decisions?
Well, I don't think they're incommensurable. I mean, he
Sure.
should.
So, like, let's say that the Department of Transportation says 10 lives will be saved because of electronic recording, but from my brother-in-law's perspective, some indeterminate number, let's say we could even make it X, would there be fewer family-owned businesses?
Sure, and those are, I mean, I'm not a big fan of cost-benefit analysis in general, and you point out one of the circumstances in which it might be deeply flawed. I think making regulatory decisions based on numbers that some PhD economist assigns to a human life or a family-owned business is fake. And all of these decisions are value judgments, and they should be. And yes, Congress should have a strong oversight role, and in fact, it does have a strong oversight role, albeit probably not in this Congress. But so I don't think the values are incommensurate. They may be incommensurate to a PhD economist, but I never even took economics. So to me, they're not incommensurate at all. And the nice thing about the regulatory process, it's far from perfect, but your cousin can write a letter online. He just goes to regs.gov and click, 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 and write and say, this rule would shut down my family business because of X, Y, and Z. And in my view, it's not worth it. I know that it might save lives, but there are other ways to accomplish that. And I think it should not be done for that reason. And the agency then needs to respond to him and the other people who have made that point. The agency needs to consider the value judgment that they're making. That's in the law already. Now, a lot of the proposals in the RAA, I don't know that I don't really care if they're bipartisan or not, but the ABA administrative law section, which has been in existence since the 1930s and is a terrific collection of practitioners and professors and judges and very thoughtful people. The ABA has been making a lot of these proposals literally for decades, and a lot of them really are no-brainers. I think that a lot of them need to be tinkered with and scaled back. And if you did tinker with them and scale them back, you would get a lot more Democratic senators on board. But anyway, that's me rambling, I'm sorry.
I know we're very short on time, so I'll just make this very fast. I just wanted to ask specifically about the REINS Act, and if Congress is authorizing major rules, what impact does that have for judicial review? Is Congress giving their voting on these regulations, giving a stamp of approval? And could there be any situation in which, after Congress votes to approve a rule, that that rule could then somehow be considered to be contrary to the plain language of the statute, or does the congressional stamp of approval supersede any discrepancies with the plain text?
Yeah, this is a puzzle to me. I'm not sure what. Just imagine that Congress approves a rule and then someone takes judicial review and says it's arbitrary, capricious, or it's contrary to the statute. It seems to me that would be an improper occasion for judicial review. I mean, there's a case at the Supreme Court right now about how Congress sometimes does pinpoint legislation to approve a particular agency action, and in general, those congressional actions are upheld as exercises of legislative power. And here, if it goes through bicameralism and presentment, I mean, they only have legislative power. So it seems to me they've legislated the approval of that rule. Now, suppose you say that what they've legislated is the approval of the rule subject to judicial review for arbitrary, capricious. That's a very strange.
But I think that's
role.
what the legislation does, though, right?
My understanding of the legislation is it allows,
Right.
it does exactly that.
But would a court accept that?
Well, why not? Congress can act in limited ways. Congress could, of course, you could write a...
Congress only has power to pass legislation.
Right. Congress could pass legislation, could write a REINS Act, which says when we approve it, all of the non-constitutional objections go away. They could write it that way. They haven't written that way. They're basically saying, look, as part of the process, you need approval by Congress. Our approval does not go to factual underpinnings, policy issues, and the like that might be subject to challenge. They can act in a limited way.
You know, I'm not sure. I'm a little queasy about it. I think it's an unresolved question. But think about the Supreme Court's reaction to efforts by Congress to prescribe standards of judicial review in the Bernie versus Flores case, and even go all the way back to Haburn's case, where Congress constituted the courts as sort of commissioners deciding, war pensions. It seems like it's an odd role for the court to be applying a legal judicial review standard to the work of Congress, and I'm not sure the courts would accept it.
Well, I'm afraid we're going to have to allow you to have the last word on this because we are over time. I'd like to thank the Federalist Society for putting together this excellent panel.